We back at 1.20 and S.28 Consumer Protection Act 1986. Dismissal of frivolous and vexatious complaints. 26. Where a complaint instituted before the district forum, the state commission, or, as the case may be, the national commission is found to be frivolous or vexatious, it shall, for reasons to be recorded in writing, dismiss the complaint and make an order that the complainant shall pay to the opposite party such cost, not exceeding 10,000 rupees, as may be specified in the order. Penalties. 27. Where a trade or a person against whom a complaint is made, or the complainant fails or omits to comply with any order made by the district forum, the state commission, or the national commission, as the case may be, such trader or person or complainant shall be punishable within imprisonment for the term which shall not be less than 1 month, but which may extend to 3 years, or with fine which shall not be less than 2,000 rupees, but which may extend to 10,000 rupees, or with both. Provided that the district forum, the state commission, and the national commission, as the case may be, may, if it is satisfied that the circumstances of any case so required, impose a sentence of imprisonment or fine or both for a term lesser than the minimum term and the amount lesser than the minimum amount specified in this section. And we at chapter 4, miscellaneous. Protection of action taken in good faith. 28. No suit, prosecution, or other legal proceedings shall lie against the members of the district forum, the state commission, or the national commission, or any officer or person acting under the direction of the district forum, the state commission, or the national commission for executing any order made by it, or in respect of anything which is in a good faith done or intended to be done by such member, officer, or person under this act, or under any rule or order made thereunder. One substituted by the Consumer Protection Amendment Act 1993, WEF 18.6, 1933. 2. Inserted ibid. We at 1.21 of the Consumer Protection Act 1986, S.31. Power to remove difficulties. 29.1. If any difficulty arises in giving effect to the provisions of this act, the central government may, by order in the official gazette, make such provisions not inconsistent with the provisions of this act as appear to it to be necessary or expedient for removing the difficulty, provided that no such order shall be made after the expiry of the period of 2 years from the commencement of this act. 2. Every order made under this section shall, as soon as may be after it is made, be laid before each House of Parliament. Vacancies and defects in appointment not to invalidate orders. 29A. No act or proceeding of the district forum, the state commission, or the national commission shall be invalid by reason only of the existence of any vacancy amongst its members or any defect in the constitution thereof. Power to make rules. 30. 1. The central government may, by notification, make rules for carrying out the provisions contained in Clause A of subsection 1 of Section 2, Clause B of subsection 2 of Section 4, subsection 2 of Section 2, Clause VI or 6 of subsection 4 of Section 13, Section 19, subsection 2 of Section 20, and Section 22 of this Act. 2. The state government may, by notification, make rules for carrying out the provisions contained in Clause B of subsection 2 and subsection 4 of Section 7, subsection 3 of Section 10, Clause C of subsection 1 of Section 13, subsection 3 of Section 14, Section 15, and subsection 2 of Section 15. Land of rules. 31.1. Every rule made by the central government under this act shall be laid as soon as may be after it is made, before each House of Parliament, while it is in session, for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, and if before the expiry of the session immediately following the session, or that successive succession aforesaid, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modification form, or be of no effect, as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity or anything previously done under that rule. I'm going to read that one over. 31.1. Every rule made by the central government under this act shall be laid as soon as may be after it is made, before each House of Parliament while it is in session, for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, or if before the expiry of the session immediately following the session or that successive session aforesaid, both houses agree in making any modifications in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form, or be of no effect, as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity or anything previously done under that rule. 2. Every rule made by the state government under this act shall be laid as soon as may be after it is made, before the state legislature. One, inserted by the Consumer Protection Act 1991, WEF 15-6-1991. Two, inserted by the Consumer Protection Amendment Act 1993, WEF 18-6-1933. That reading was the Consumer Protection Act of 1986. I want to say 1986. Yep, the Consumer Protection Act of 1986. Thank y'all for listening. That was that read.